Good morning. Wow. My name is Carl Hayes, and I'd like to welcome all of you on behalf of the Texas Family Law Foundation to this seminar that we're putting together this morning. We're calling it basically What in the World, How and Why Foreign Law Sometimes Gets Involved in Texas family law cases. First, I'd like to thank Representative Smithy for arranging this room for us so that we can have the, am I too loud?
No, we need to be a little louder.
Oh, a little louder, okay. I was stepping away from the mic. This good? It's a great room. I'm surprised that some of you didn't choose to sit at the table behind the column so no one could see you. I do understand that you all have other responsibilities and that you may have to, during the course of this morning, leave to go to committee hearings or to respond to other requests, and so that's perfectly okay. Feel free to get up and leave whenever you need to. Just remember that we are having free lunch, so if you can make it back here by that time, and I think that's probably why all of you are here, right? You got the announcement there is going to be a free lunch. So if you can make it back by that time, we will. We have plenty of box lunches to go around. I want to orient you to the paperwork that you've been given. It should have been delivered to your offices yesterday. There's a couple other documents that are on the table, but a lot of that information, it's resource information. We're not going to go page by page through all of that this morning. In fact, if you find that you're unable to go to sleep one night, you might want to pull out one of the law review articles and read it, but they're good resources. And essentially what we want to do today is just provide you with an overview of how foreign law gets involved in particular in family law cases. We noticed that in the foundation that over the last few legislative sessions, there's been a lot of discussion and legislation proposed about foreign law in family law cases, and we realize that during the course of a session, it's much too hectic to provide any sort of real education about exactly what the issues are involved in the application of foreign law. So thank you very much for being here. At the end of today, you're going to you have your resource information, but also we'll provide you with email addresses for those of us that are involved in the seminar today, so that if you have any questions or constituent questions that you want to present to us, you can certainly send those, and you'll have a contact point with individuals in the foundation and who are involved with the foundation, so that we can help you with that. I'd like to take just a second and introduce the other speakers who are going to be involved in this. I'm not going to ask them to stand because you'll see them when they come up. But in addition to myself, we have Brian Webb, who is an attorney out of Dallas. He's a board-certified family law attorney like myself. We are going to have two district court judges speak to you later on this morning. One is District Judge Denise Garcia out of Dallas, and the other is District Judge Bill Henry, who serves down in Hays County. And in addition, this afternoon, because foreign law not only involves issues of the law of other countries, but also involves religious law, we're going to hear from three religious leaders. We have Rabbi Neil Blumhoff from Austin, we have Aman Mujahed Bakash of Fort Worth, and then Kyle Sears, who is an attorney mediator who is going to speak to us about Christian conciliation. As I mentioned, we'll take a break at 11:45. That's when the lunches are going to be here, so if you have to leave, get back here for that. And now let's get started with the program. We're intending as part of this program to talk about first generally how foreign law is involved in the United States courts, federal courts, and state courts in general. how Texas applies the laws of other states and also foreign countries, how the constitutional law, treaties, and statutory and public policy reasons limit what the courts do with respect to applying foreign law, and things that the legislature has already done to make sure that citizens of Texas are protected by the misapplication of foreign law. And when we're talking about foreign law, we're not really talking about, some of our statutes speak of foreign law in terms of the law of another state. And in Texas, as far as we're concerned, any other state is just a foreign country to us. But we're not talking about Louisiana law or Oklahoma law. We're talking about the law of another country, like England or Spain or any other country in the world, and how that law affects the laws in our state. And as I mentioned a moment ago, we're also talking about religious law, because whether it is a Protestant religion, Catholic, Islamic, or Judaism, all of those religions have their own set of laws that members of those religions also adhere to. And quite often disputes are settled by individuals utilizing those laws. And we're going to talk a little bit later on this afternoon about how those settlements interplay with our legal system, and how participation in those processes, like Christian conciliation, how that interplays with our court system. But how does foreign law, just in general, get involved in Texas courts? Because we all think of the fact that we're in the United States, we have our own set of laws, we have federal laws, and then in the state of Texas we have our own state laws. So why in the world would we ever have occasion to look to the law of any other country? Well, first of all, the Supreme Court has done that on several occasions. And they usually do it when they're looking at big policy issues. For example, over the last few years, the Supreme Court has looked at a number of death penalty cases. And when they're deciding issues on the death penalty, say, for example, whether an individual who is mentally challenged should be subject to the death penalty, or a juvenile, someone who commits an offense when they're under the age of 18, whether they should be subject to the death penalty. When the Supreme Court of the United States has looked at that issue, they've looked at how other countries in the Western world address the death penalty. And they've considered how European countries treat the death penalty, or how other countries have dealt with it. So the federal government occasionally does look at foreign law. And a case that I was involved in 2010 was the Abbott versus Abbott case that I actually had the honor of arguing before the U.S. Supreme Court on, and it dealt with a custody case out of Chile, and the Supreme Court had to look at Chilean law and decide whether under Chilean law the child who was the subject of the lawsuit needed to be returned back to Chile or could remain in the United States. And that's an issue that went all the way up to the Supreme Court, and the Supreme Court had to look at Chilean law in order to make a decision. And they also looked at how other countries dealing with similar type issues had answered the question that was before the court. But those are more esoteric issues that when we're talking about how the federal government, how the Supreme Court deals with foreign law. Let's take it down to how the state of Texas deals with foreign law, and how in the world we would ever come to have to deal with that, because the state of Texas doesn't have to make these big decisions that the United States Supreme Court does, dealing for the country as a whole. In the state of Texas, there are numerous instances where foreign law comes into play. For example, in family law cases, there is an Oklahoma Law Review article that you've been given a copy of, and if you get the opportunity to look at that article, you'll see that there are a number of examples in there where foreign law, about how foreign law comes to play with regard to the states. And for example, in family law cases, there's a case of Ghassemi versus Ghassemi, which is a Louisiana case that involved an Iranian marriage. And in that case, Louisiana had to determine if two people who were married in Iran were actually legally married. And so Louisiana, applying their law, which required them to look at the Iranian law to determine whether the marriage was valid, looked at that law. And the question in that case was, under Iranian law, they allow first cousins to marry. Well, in Louisiana and several other states in the United States, they don't allow first cousins to marry. But Louisiana was bound to look at that law and determine that it was a valid marriage. Courts do that in Texas, do that all the time when people from who have been married in a foreign country come to Texas looking to get divorced. They have to first determine whether or not the person, the couple, is in fact married before they even step into the realm of seeing whether handling the divorce. There's also tort cases. And tort cases are personal injury cases where someone sues because they've been injured. Say, for example, two Texans go south of the border and they're driving around and they get in an automobile accident. The driver of the vehicle gets sued by the passenger who is injured. And both of them are Texas residents, so they sue in Texas. But the passenger says, you were violating the law because you were speeding. You were going too fast. Well, does a court in Texas go, well, let's look at the Texas speed limit? No, they don't. They say, what was the speed limit where you were at in Mexico? And were you violating the law in Mexico? And it requires the court to look to see what the law was in Mexico and then apply that law in determining whether the driver was negligent because he was speeding. And in contract cases, there's an example in the Oklahoma Law Review article about two soldiers who were in an automobile accident in Germany. And the soldiers were subject to a insurance policy that had been issued by a German company. And so the court, and in this particular case it was Oklahoma, the Oklahoma court had to interpret the coverage based upon German law, which is something that happens all the time in commercial cases. We are a global economy, and there are individuals in Texas who do business with companies all over the world. Sometimes those contracts provide that if there is a dispute, Texas law will apply. But sometimes those contracts provide that in the event of a dispute, foreign law will provide the answer for whatever the dispute is. And for example, if I'm contracting with a company for services out of England, they very well may say in their contract that if I have a complaint, I have to deal with it in the English court. And that happens routinely. And it works. And the reason why it works is because England will acknowledge our judgments, and we will acknowledge judgments that were issued by England. And we even have, and it's a mouthful, it's the Uniform Foreign Country Money Judgment Recognition Act, which means that if there is a foreign judgment that is entered in another country, that judgment will be recognized, provided certain steps are taken, will be recognized in Texas. And the reason why we do that is because of a principle that Mr. Webb is going to talk to you about. That's the principle of comity.
Sounds like my cue.
That is your cue.
Good morning. Brian Webb from Dallas. One of the issues in Dallas is what do we do with the state fairgrounds when the state fair isn't in session? And what's more like the state fair than the state legislature? So I'm glad y'all have solved the problem of using this fairgrounds during the off season because we're not that far along in Dallas. Talk to you a little bit about all of this stuff over the course of the day, but first of all, I want to say we're not here because we're for or against any particular legislation. Way too early for that, obviously. What we are here against, if you will, as family lawyers, is unintended consequences. And so we've got a pretty complex system that reaches out into a lot of areas, and we want to make sure we guard against some general statement sort of upending the apple cart. So what I've been assigned for this particular segment is full faith and credit within the U.S. versus comity, which is the recognition of each other's laws on a worldwide level. We have the full faith and credit clause of the Constitution, which basically says within the United States, we all honor everybody else's laws. So if you sign a contract in Colorado, you can get it enforced in Texas. If you form a corporation in Delaware, it can function in Texas. All of those things are mandated. If you are divorced in Illinois and you come to Texas afterwards, you can get enforcement of that divorce order here because we recognize each other's laws and we're required to follow them. When you get on the international scene, we rely on Comity, and that is C-O-M-I-T-Y. It's sometimes it's C-O-M-E-D-Y, but Comity with the T is what we're looking at here. And that's always been a creature of agreement. It's a voluntary system. It's a creature of politics, if you will. It's you scratch my back, I'll scratch yours. The most significant area that I'll talk about later on today probably comes in the field of international treaties involving children. We have a Hague Convention on International Child Abduction. That treaty covers the signatories of the treaty, but the rest of the world, which is still most of the world, has those same issues of children being abducted across borders, and they deal with it on the basis of this voluntary system of comity. If someone comes to Texas, snatches a child, and takes them to another country and tries to start a lawsuit there, what do I do about that in Texas? Well, there's nothing I can do unless I have some sort of an understanding in place with that other country. That's where the Hague Convention came from, and that's how we deal with non-Hague issues right now. And the bottom line is on it, if you'll give me my kids back, I'll give you your kids back. And that's how the system works. And if somebody refuses to do it, they refuse to do it. So we have this concern that if there are new elements thrown into a system where lawyers can then begin to say, but Judge, we have this law in Texas that says we can't apply any foreign law. All of a sudden you raised a defense that throws a stick in the spokes at a very local level and threatens to disrupt that system, because now what is a pretty automatic return system, or certainly designed to be an automatic return system, is no longer automatic. And if we're not giving their kids back, they're not going to give our kids back. And so we want to make sure that none of that gets damaged in all of this. And we're really very fortunate. One of the documents you have in here, I think, is the AG's, the request for an AG's opinion. But I don't, maybe you don't, but there is a request that's to the effect that Texas covers what has been proposed in prior bills in terms of addressing the problems. We have lots of safeguards in place that if you don't have due process where you are, if it violates Texas policy, Texas courts can already deal with that. So we're trying, the Hague part of it, the treaty part of it, is simpler in the sense that at some point the federal government will impose something to make sure that works. Although that would create havoc for lots of families along the way. The comity portion of it, which is purely voluntary, we just want to be sure that that stays functional. A imagine a child in your family all of a sudden appearing on a continent far, far away. How do you get that child back? Well, there's a very elaborate system that's been built up over the years that relies on this sense of comity being adhered to by the players on both sides. And if you take that away, then that particular child may not come back during their minority. Eventually, people will get together and solve the problem. But for that child, if it takes 10 years to solve the problem politically for an 8-year-old child, you've lost the childhood of that child. It's a very significant thing to deal with when you take it down to a personal level. So again, full faith and credit. We have to honor each other's things within the country, or those things, we call them laws. And comity on an international level, it's cooperation. It's what we as lawyers do all the time when we negotiate, certainly what y'all do down here all the time. That's sort of the backbone of the system, and we're hopeful that we can help to avoid that being damaged some way inadvertently. Thank you.
It's the slow clap. Now, Brian mentioned that comedy is, it's fair play, it's reciprocal, but the issue comes up, do we always have to reciprocate? I mean, if basically if someone wants to play nice with us, do we always have to turn around and honor that and play nice back with them? And there are limitations to it. We do have limitations that apply to limit when we have to comply with foreign law. And to speak on that, I'm going to turn this over to Judge Garcia, who's going to talk about those limits on comedy.
Good morning. What an interesting, fun thing to do in the morning, right? Before I start, I want to get an idea of how many lawyers we have in the room. Any lawyers? Okay, so some of you have understanding of minimum contacts, international shoe, but many of you don't, right? I say international shoe and you're like, what, my Italian shoes? No. Comity, so what we've learned so far today is foreign law happens. It's been happening since we've been a country. Next, we learned that the way that we deal with foreign law is called comity, not the kind that makes you laugh, but the kind that talks about we get along by enforcing each other's law. Now, there are some times when it's not a good idea to enforce a foreign jurisdiction's law. And I know we're talking about foreign countries, but as Carl said, we're in Texas, and in some ways, we consider anything outside the borders of Texas as foreign. And so when I was first asked to speak on this, they said, will you speak about foreign law? I said, do you mean foreign from California, or do you mean foreign from France? And the focus is France, but some of the ideas and the ways that we handle foreign law are similar. And I can give you the best example by telling you about surrogacy laws, for example. We have very different surrogacy laws in Texas than they have in California. And if someone goes to California to try and get a surrogacy contract, and they come to Texas, there are some aspects of that contract that we find against public policy in Texas or in other jurisdictions where they allow payment for a surrogacy. In Texas, we see that as selling babies. We don't sell babies in Texas, so that's a contract that's not allowed in Texas, and we find other ways to find a way to help the family through the conflict. I do primarily family law, so my context to you today is going to be from the perspective of family law. Comity is reciprocal. It allows the decisions of the U.S. and other states to be honored, and vice versa. The things that are going to keep us from recognizing statutes from other countries or foreign judgments from other countries have to do with the basic ideas of due process. Due process is guaranteed to us under the 14th Amendment of the Constitution, the United States Constitution. That's something we all generally understand. A foreign judgment is not conclusive in Texas if it was rendered without an impartial tribunal. Without an impartial tribunal, You cannot have due process. If there is no personal jurisdiction over the person, that is not conclusive in Texas. If there's no subject matter jurisdiction, that is not conclusive in Texas. Thank you. I was beginning to think, am I too short? I carry a stool around with me so I can make it over the podium if we have one. In addition to that, a foreign judgment does not have to be recognized if the defendant didn't receive notice in time to defend against the lawsuit, if it was obtained by fraud, or if it's against public policy. There are two cases that kind of speak to this in Texas that we have. One is Seth versus Seth. It's a case from 1985, an example of a divorce that was granted, an Islamic divorce that was granted in another country but was not recognized in Texas. Ashfaq versus Ashfaq is a case where a Pakistani divorce was granted, but it was recognized. And so you may be wondering, Judge Garcia, how did that happen? I thought this was pretty clear, and it sounds like maybe there are unpredictable results from this. Well, the two cases are distinctly different. In Seth versus Seth, you had a situation where a gentleman married a woman. He met another woman, wanted to marry her, and in doing that, became Islamic, so that he could perform what was called, is it talaq or tarek? It's a divorce, and the idea is I think you've all probably heard this before. You say, I divorce you 3 times, and then the divorce is granted. That was not recognized in Texas, because you didn't have what? No personal jurisdiction? No notice, definitely no notice to the first wife. There was no opportunity for her to defend that case, so it was not noticed. That's an example of how comity has its restrictions. The case where the divorce was recognized is Ashfaq versus Ashfaq, and that's more recent. And the reason that was recognized was because even though the wife didn't participate in the proceeding, she had notice of the proceeding, and she had an opportunity to defend against it. Maybe there's a question about jurisdiction, but if you look closely at divorce jurisdiction in the United States, and this is where law between states comes in. If you have a couple who was married in Arkansas, born and raised there, spent their entire lives there, and the husband moves to Texas, intending to make Texas his residence, lives here for 6 months, meets the residency requirements, he can file for divorce, serve his wife in Arkansas. She has no contacts with the state of Texas. Now, if you've taken the bar exam, you have an idea about the differences between the UCCJEA, the UIFSA, PKPA. These are all, we call it the alphabet of jurisdiction in family law cases. But there's a special kind of jurisdiction called divorce jurisdiction, status jurisdiction, where we don't have to have personal jurisdiction over the other party to be able to grant the divorce. And the reason for this is that our forebears, the people who preceded us in the law, came up with the idea that states have the right to determine the marital status of its residents. So you can grant a status divorce without dividing the property of the parties, without making rulings regarding their children. Those issues are dealt with by different types of law. Custody, UCCJEA. Child support, UIFSA, UIFSA. Property, international SHU, minimum contacts. Divorce is status jurisdiction. So that when Pakistan exercised its jurisdiction to grant the divorce, they were doing nothing different than what we would do in Texas, what they would do in Arkansas, what they would do in Nevada. This is the law of the land. So that it wasn't something that was against public policy. It wasn't something against our notions of what fair jurisdiction in this type of case is. The property in Ashfaq versus Ashfaq was not divided in Pakistan. The parties came to Texas, where their property is, and Texas divided the property. So that's the difference between Seth versus Seth and Ashfaq versus Ashfaq. It's a distinction. You may think it's a distinction without a difference. It is a distinction, and it has very intricate roots in our concept of comity and what gets recognized and what doesn't get recognized. So if you're thinking about the issue of, oh my goodness, a divorce got granted somewhere else and she didn't have a chance to participate, you have to think a little bit more deeply than that and go a little bit more deeply than that. The issue of public policy, we are given guidance in the family code, in a family context, for what is against public policy. First cousins can't marry each other. Now, about 20 years ago, that was different. We changed that in 2004. It was okay in Texas until we had some, an influx of immigrants from another state, that is, I think, Nevada. We changed it to where first cousins can't get married, but that's our public policy consideration, for example. Another one has to deal with, if you look at the PKPA, ways to prevent parents from absconding with their children to another country. And Brian is very modest. Hague Convention's a very useful tool for getting children back to the United States. Even when another country is not a signatory to the Hague Convention, there are methods in our family code that help us, that give us the tools that we need to get children back, provided we have that system and it's not disrupted. He managed to get a person, it was a case out of my court, we held someone in contempt, and by the end of the week, we had children back in the United States. So the tools that we have are important, they're complicated, and we don't want to, we want to avoid the problem of upsetting that apple cart, that we might lose some tools, we might have some common law tools that we have at our disposal by virtue of the fact that we try to handle it in a way that doesn't foresee unintended consequences. So with that, I'm going to turn it back over to Carl. He'll introduce the next speaker. Thank you.
I'm going to share with you a rather interesting statistic. And I did not actually believe this. I was Googling the, because everything on the internet is always true. I was Googling about, I wanted to know how many people who were married out of the country were in the United States, how many foreign marriages there were. And this is from the United States Census, and this is as of 2013, 21% of married couple households in the United States, that's 1/5 of every married couple households, have at least one foreign-born spouse. So that's 20% have at least one foreign-born spouse. And then of those where there is a foreign-born spouse, at least a third of those marriages were conducted out of the country. Because there are instances where someone will bring a fiancé into the United States and get married here, and they would get married under the laws of whatever state they were in. But that means that there's a large number of married couples who have been married in other countries and are living here in the United States and are United States citizens, or their spouse has residency status. And so when those people go to get divorced, foreign law often plays a role. And what we're going to talk about now, that's just one example of how foreign law becomes involved in family law cases. And Brian Webb and I are going to kind of tag team this. So Brian, I'd invite you up. We're going to talk about those instances where foreign law does come into play. And the first thing what I just mentioned was in recognizing foreign marriages. Because let's say a couple gets married, and we have thousands of servicemen that are stationed in the state of Texas. And a lot of those individuals, when they're overseas, will meet somebody, get married, and will bring their wife back or their husband back to the United States. If they move to get divorced, one of the first things that a Texas court would have to do is determine whether they were validly married. And you'd be surprised at the number of instances where that is something that someone will contest. They'll say, well, we didn't get validly married because we just had a religious ceremony and we never got a marriage license when we went on our trip down to Jamaica, we weren't really married because the ship's captain married us and we were drunk and we didn't really mean to get married. But those things happen. And so the court has to look at, well, what was the law that was in effect wherever you got married? And so they have to look at the recognition they have to look to see whether they recognize a foreign marriage. Brian, can you speak about recognizing foreign divorces?
Yeah, and it's always been, of course, Mexico is the obvious, most often recurring locale that we deal with. But if somebody gets a divorce in another country and then comes to the U.S., the question is then, do we recognize them as divorced? Well, we do. For the most part, we do. So if you had a system where that wasn't the case, if for some reason somebody had to come in and reestablish whether they were married or divorced, you got married in Texas, you went and you lived in France for 15 years, about year 12 you got divorced, you went your own way, one of you came back to Texas and now is claiming to be single. Well, unless we're recognizing that foreign divorce, you're still married because you didn't get a Texas divorce. So those kind of implications come up. All sorts of destination weddings go on these days, a lot of them in Mexico. By the way, my advice, get married in the States, go to Mexico, have a lovely drunken ceremony, and come back. Because when you get married in Mexico, you get married under Mexican law. And there's some kind of deal they do where you have to pick which property scheme you're going under and all. It can be very messy. So that marriage will be recognized. But a Mexican divorce gets recognized as well. It gets a bad name and it gets a sort of strange reputation because people say, well, yeah, he ran off to Mexico and got a quickie divorce and came back. Well, I think those days are kind of gone, but lots of legitimate divorces take place in Mexico and in France and in England and in Pakistan and all over. So it's very important that we recognize those things. And by the way, I want to go back to the thing that the case Judge Garcia mentioned. And I said something earlier about the impact on a child's life if we don't have these things in place. In that case she was talking about, we were able to bring 3 children back from Bangladesh who had been abducted there by their father, and the mother had not seen them except under the most onerous supervised conditions in 5 years, and one of the children she hadn't seen since it was basically a newborn. And because all this stuff is in place, they were brought back here, brought back to the country they were stolen from, and their life went on as it was supposed to.
Well, and that segues into the next thing that we wanted to talk about, and that is, in addition to issues dealing with foreign marriages and foreign divorces, Texas courts often have to deal with issues involving child custody, and it's custody decrees of other states and also custody decrees of other countries, because we live in a global society, and it is very easy for families for one parent to take the kids, put them on an airplane, and fly them out of the country. Whether it's to fly kids, as in Brian's case, they took them to Bangladesh, or it's someone from another country fleeing to the United States and bringing the children here. Brian talked a little bit about the Hague Convention, and that is an international treaty that the United States is a signatory to, which assists in the return of children that are taken from the United States or from a foreign country. And I'll let him talk about this. It involves a determination of what the law of the particular country that the children were residing in. There are certain things that a Texas court, let's say for example, children are kidnapped from England and are brought here. Brian will talk a little bit about what a Texas court has to do in order to determine whether those children are going to be returned, and it involves interpreting foreign law and not the law of the United States.
First of all, let me say, I understand that unless you have an ongoing Hague Convention case in your life, it's probably pretty boring to you, so I'm not going to go into too much detail. But here's how it works. The treaty was developed, it was signed off in 1980. The negotiations had gone on for years before the international community meeting at The Hague, which is where the name comes from. And actually, the Hague Convention on International Child Abduction is drafted in two original versions. There's the English version and the French version, because they couldn't agree on certain phrases being translated exactly enough to suit the French. Anybody French here? Okay. All right, it's your fault. So there's two. So that's how complicated it was to put together and get the world in on. So what happens is you're sitting in your house in Austin, Texas, and you wake up one day and you look in your kid's bedroom and your kid is not there. What do? Your spouse has taken your child someplace else, across the ocean. And now you begin the process. Well, one of the things that's important for the Hague Convention to function is for the court who's now going to first hear this, which is going to be the court where the child has been removed to be able to determine whether you, as the left behind parent, was exercising your rights to custody and or visitation of the child. And in order to do that, they have to be able to look at Texas law to determine what constitutes custody and possession and visitation, and then whether you were exercising. And now Texas is the foreign law that they're looking at, okay? You reverse that situation and you have the wake up be in France, the child's been absconded to Texas. Texas has to be able to look inside the French system at what their law is as it applies to custody and visitation in order to take those very initial steps to bring the child back. And what you're dealing with, and let me make this clear, in a Hague Convention case involving child abduction, you're dealing with which court system will hear the case. That initial decision isn't who gets custody of the child. It's not who gets the child ultimately. It's where is the best place to try the case over custody of the child. Where's the place where the teachers are, the friends are, their life. It's called the habitual residence under the convention. Where is the child's life centered? So that's what you're looking for, is to pick the right court. If somebody in Austin picks up a kid and runs off to, say, God forbid, Dallas, and then files a lawsuit in Dallas. The child's been here all its life. You've been in Dallas 90 days now. You're there long enough to file the lawsuit, technically for venue purposes. But I think we'd all agree the right place to try it would be back down here in Austin. And that's all the Hague Convention's about. But without the ability to look into another country's law and see what's going on, you can't begin to make those initial determinations that are so crucial. And again, when that breaks down, the idea of the Hague Convention on abduction is to give you the closest thing the international community can give you to instant relief. My baby is gone. I want my baby back. Here's the quickest remedy that the international community has been able to devise. And if you create unintentionally a situation where lawyers will then come in defense and say, Judge, we here in Texas don't look at foreign law. Now you've got a problem for the judge to deal with. You've thrown a new wrinkle in. And I'm going to submit to you, you haven't added anything to the jurisprudence, because we're very, very fortunate here in Texas that the legislature over the years has been attuned to these issues. And I can't think of a single problem that could arise involving foreign law that Texas law does not already allow Texas judges to deal with. So you're not adding something new. And while I'm on Hague issues, let me throw in one more. Get the site right. There is now a Hague Convention on child support collection. And if you go to the last legislative session, Section 159, 601, and forever after that in the Family Code, you will find that the legislature in the last session made numerous additions to the Family Code to accommodate that child support treaty. So we've added phrases like, or a foreign support order to our statutory scheme, or a foreign country. There are literally dozens of these new references to foreign law and the actions of sometimes foreign tribunals and the actions of what are now, in some instances, Texas tribunals, not a word we're used to here. But the point being, in order to accommodate the international nature of all of this, the treaties have been incorporated into local law. This new treaty now has been incorporated into Texas law, so it functions. The people who actually operate under it are mostly the AG's office and the local Texas courts. But the ability to look at foreign orders is key to making the whole system work. So if you want to be able to collect your child support from somebody who's run off to another country and do it in a reasonably feasible way, this is the way to do it. And we've just put all that stuff in, and any kind of sort of a general reference to doing away with referring to foreign law is going to require now to somehow go back in and pull that out and yet try to find something to replace it with that would allow the treaty to function. So it's not many people do Hague Convention work, and I don't blame them. Not many people do tax work, and I don't blame them. But Hague Convention work is dealing with small lives in finite periods of time across huge, vast distances. You're talking about a system that incorporates two governments getting together to enforce a treaty, lawyers on both sides trying to implement the treaty, all with the idea of getting kids back to where they belong. And there's a huge concern that whatever gets done in this area, if anything, be done in such a way as not to interfere with those little lives that are really the ones at stake in that area.
This is totally unrelated, but standing here and watching Brian, I forgot to mention at the beginning that we are videotaping this, and we're going to publish it on YouTube. And the reason why I was standing here thinking about that is I was going like, my gosh, I hope I don't look like Chris Christie standing behind Donald Trump.
Well, I hope I don't look like Chris Christie either.
But we are going to have this available so that if you know people that weren't here, or if you want to refer a constituent to look at the video, it is going to be posted right next to all of the cat videos that are on YouTube. In addition to foreign marriages, foreign divorces, and child custody decisions, another area where foreign law comes into play quite often in family law cases is with premarital agreements. Individuals who, remember I told you this statistic about those individuals getting married in foreign countries. A lot of those individuals who come from Islamic countries will have a premarital agreement. And it's up to the Texas court in those instances when people are coming in to get divorced to interpret that agreement and make a determination as to whether that agreement is enforceable. And Texas law provides for certain requirements that have to be met for there to be an enforceable premarital agreement. We have procedural laws in place about what needs to be done to enforce that agreement. And we also have public policy concerns about that need to be taken into account in order to enforce an agreement that is done in a foreign country. But courts routinely, when there is a foreign divorce, are called upon to look at the premarital agreement, and if there is a premarital agreement, and decide whether or not that should be enforceable. Now, Brian had mentioned this, and we do have, we've had a legislature that has gone above and beyond in terms of making sure that individuals in Texas are protected in terms of our public policy. And just to show you some of the things that have been done, we have a Uniform Act that involves child custody. Other than the Hague Convention, there is an act that if someone kidnaps a child and takes them to Oklahoma, we have a reciprocal Uniform Act with the state of Oklahoma that allows for the return of the child. It's the Uniform Child Custody Jurisdiction and Enforcement Act. That act, by one of the provisions in it, also applies to internationally, because states are not only states in the United States, it's also foreign countries. But there's a section that is included in Section 152.105 of the Texas Family Code, which is the section entitled International Application of Chapter. Section C says, a court of this state need not apply this chapter if the child custody law of a foreign country violates fundamental principles of human rights. So we have already in our custody laws a provision that says if someone is trying to enforce a foreign law and say we want this child returned back to a country that has child labor, where the child's going to be put to work and it's going to violate child labor laws, or they're going to be a child bride, or something which is repugnant to our public policy, a judge can say, I'm not going to enforce your child custody decision because it violates fundamental principles of human rights. And we have that in our law. We also have similar provisions in the adoption statutes. If someone wants to try and enforce a foreign adoption and say that they adopted a child and it was a legal adoption, the court in Texas can say we're not going to approve your adoption, we're not going to recognize that adoption if, again, it violates fundamental principles of human rights. And in the realm of child support enforcement, in the statute that Brian talked about, that in this last legislative session, the legislature amended to recognize or to assist in the enforcement of foreign child support orders. Again, there are provisions where a court, if there were certain due process requirements that were not met. If someone comes here and tries to enforce a foreign child support order and the Texas court determines that there was never a hearing in the other country, the person never got the opportunity to present his side of the story or have his day in court, then the Texas court can say, we're not going to enforce this order because it wasn't fair to the person you're trying to enforce it against. And we have those provisions already in place in Texas law. We also, the state of Texas is one of just a handful of states that has a very comprehensive statute to protect against international kidnapping. We have an entire chapter of the Family Code that authorizes a Texas court to look at various factors that might lead to there being a kidnapping and to take steps to prevent a child from being kidnapped and removed out of the United States. So, as I was saying, we have a number of provisions already in Texas law that provide a court with the tools necessary to say, look, we're not necessarily going to enforce this foreign law because either it violated due process where someone didn't get their day in court, or it also or it violates public policy because it just isn't right. It violates what we as Texans believe is fair and just and right. And you see, Brian, that kind of segues into in addition to the Hague Convention, we also have a Parental Kidnapping Prevention Act. And is there anything that you wanted to say with respect to that?
Hang on just a second, go ahead.